Okay, welcome to the 5th Annual Symposium on Family Court Issues, sponsored by the Shared Parenting Council of Connecticut. I'm John Clapp. I'm an emeritus professor at the University of Connecticut, where I am still doing social science research in the business school. And I'm also chair of the Shared Parenting Council of Connecticut. We're a group of volunteers who volunteer our time and money to promote the idea that in most divorce cases, the presumption of equal parenting time and responsibility is a starting point for negotiation between two fit parents. This is based on substantial social science research showing that children in shared parenting situations, co-parenting, parallel parenting, nesting, whatever it is, that they do much better in terms of their outcomes, behavioral outcomes, academic outcomes, mental health outcomes. They do much better in shared parenting situations. Clarify that the Shared Parenting Council of Connecticut is not a dad's rights group. It is not a mom's rights group. It is focused on children and what works for them according to research results and to our own experience. I've been working on this for about 25 years, and it's pretty clear that my children, my grandchildren are doing a whole lot better with shared parenting than they would have otherwise. When we talk about fit parents, of course, in today's seminar, I think we'll probably hear a little bit more about the extreme situations of parents who are not fit to co-parent or parallel parent or whatever. But we start with the definition of the DCF, the Department of Children and Families, and I won't go into detail on that now. We envision a society in which future citizens, our children, grow up with a balanced and healthy relationship with both parents. So the Shared Parenting Council is delighted that Chief Administrative Judge Michael Albus has made major changes to Connecticut's family court system over the past 2 years. These changes fall into 3 categories. First, Judge Albus, about 2 years ago, introduced the new triage and pathways approach, a method that encourages mediation, not litigation, as a first response to separating and dealing with the emotional turmoil, the high anxiety, the financial difficulties associated with split household parenting from split households. So I'm focusing here on the typical situation in family court. So this is a situation I experienced over 25 years ago, but also I think many parents experience. First of all, they're in various stages of grief and anger about the loss of the dream. They had a dream of a happy family life, and it's gone now. And secondly, they're in very high anxiety about what's their relationship going to be with their children in the future. Thirdly, they're financially distressed by the problem of parenting in separate households. And it's our view that in this typical situation, the last thing a parent needs is someone to come knocking on the door, and that's a marshal delivering papers from the court, telling them that there's the court and the legal and professionals are going to decide their future. We don't need the court to decide who's the better parent, who's the primary parent, who's the custodial parent, et cetera, et cetera. I don't know how that, you have to go back hundreds of years to figure out how that happened, that this is a default situation for these emotionally distressed and anxious parents who are splitting the households. But somehow it is, and we're going to change that. And that is being changed, and we compliment Judge Albus, compliment him for his triage and pathways approach, which the first stop is now not the court papers, but with a family relations officer who tries to triage, guide the family to solutions that will work for them and their children, especially their children, over their entire lifetime, and not just today. We don't know about the training of there are more than 25 new family relations officers hired recently under triage and pathways. We don't know much about their training. I'd love to know more. We certainly hope that they are exposed to the literature, which shows clearly that children are better off with shared parenting. A second major focus of family court reform has been enunciated by Judge Malkosh. He has stated that courts should refocus high conflict cases on the children, in his words, like a laser. And recently, Judge Malkosh said that, quote, in a quest to achieve fairness and to give the benefit of every doubt, the system has allowed itself to be tied into knots, end quote. And I understand this as to be a signal, this coming from Judge Albus and Judge Malkosh and other judges, that they're not going to allow this knot tying to continue into the future. I could go back many years to Tauk versus Tauk, a famous, infamous Connecticut case, which shows knot tying par excellence, did not focus on the children. The children suffered tremendously. And then the third major thing is, again, from Judge Malkosh, from his decision, we see a lot less tolerance for that minority of lawyers and court professionals who are exploiting the system and dragging things out and filing unnecessary motions and all that. Recently, Judge Malkosh sent a strong signal to that minority of lawyers and other professionals that if they don't focus expeditiously on the best interest of their children, they're going to have to face him and explain why. And my advice to them is, well, good luck to you. And so that brings us to Shared Parenting Council and what we're doing. And we've really recently refocused our website, which you see here on your screen, on resources for parents in split families. And there are many ways to get to those resources. You can scroll down the page and see a lot more, but just click almost anywhere on this page, and you'll come to a major resource that we're providing for parenting. First is a list of Connecticut mediators. So you will find, if you click here, a list of skilled professional mediators who are experienced and understand the need to focus on the children and to reduce conflict through alternative dispute resolution. And then we have a list of these are Connecticut mediators, I guess I said that. These are, then you have a list here of financial analysts. These are certified financial analysts. They've done a fairly rigorous program through IDFA. And they're all Connecticut-based too. All the contact information is there. And then there's more information, our best understanding of some new procedures that family court offers to separating parents. So you don't get that knock on the door and you don't get served by a marshal, which is the worst possible thing in most cases, in my opinion. But I guess I've already said that. Okay, so now that brings us to Colleen O'Neill. And I've emphasized the need to work through emotional, financial, and practical difficulties, not just today, but for the whole lifetime of your life with your children as they grow older. I now have grandchildren, and it's been wonderful that my ex and I have been able to co-parent through all of that. And Colleen is an expert on that. She is a highly trained, experienced and skilled divorce mediator, a therapist, an educator, a social worker. She has a Master of Social Work and a Master of Education, and she has successfully implemented solutions for divorce mediation and difficult post-divorce issues, most recently through her private practice in Westport, Connecticut. Colleen.
Thank you, John. And thank you all who are in attendance today for the 5th annual Shared Parenting Symposium. It is our goal to learn and grow from the presentation and from the dialogue shared afterward. Families here in Connecticut and around the globe share the common thread of family. It's nothing more important really to any of us. And the more we can improve the lives of children in those systems, the better. Connecticut legislators and citizens continue to work toward more comprehensive laws surrounding families, as can be seen with new domestic violence laws with the passing of Jennifer's Law supporting coercive control in domestic violence here in Connecticut. We continue to seek improvements in our family court system, recognizing the need for change in a system that no longer is accomplishing what it truly was meant to accomplish, which was what is in the best interest of our children. And it is no longer accomplishing what it was once meant to accomplish, which was to serve our families here in Connecticut and to serve our children and parents alike in the most effective ways possible. I find it encouraging today to see so many of us, legislators, the public, professionals, coming together to help strengthen our children and families that may find themselves in need of our court system. With that said, please allow me to go over a few items with you today. For the purposes of enjoying our time here today, we have a few ground rules to keep things flowing smoothly. Following introductions of our presenter, we have set aside time for questions and answers. We would like to acknowledge that any legislative guests that are in attendance are here for the sole purpose of listening and learning, and in no way are endorsing shared parenting or the presenter. We will commence with questions from any legislative guests that may be in attendance first, as they have to attend to other things, followed by others that are in attendance. In order for anyone to pose a question, please either raise your hand with the Zoom feature or post a question in the chat box. If you wish to remain anonymous with your question in the chat box, please indicate that so we know. We will keep everyone on mute during the symposium until that person is set to speak. These discussions, understandably, may be filled with many emotions. It is about families and children and courts. That does follow emotions. Please know we have these forums to host necessary discourse to improve ourselves and our society, and we can only do that by respectfully listening and speaking to one another. Our common goal for our children is to grow up with a balanced and healthy relationship with both parents, while often recognizing that they may not always be the case, but in the situations that it does allow, that is what we seek. For the legislators that are in attendance today, please let me introduce them. We have Representative Robin Comey. She's in her second term as Brantford's 102nd District State Representative. Her background is as a community and parent advocate for education and health issues, a nonprofit leader and small business owner. She was recently inducted into the Brantford Education Hall of Fame for her extensive work in early childhood education and serves on several local boards and committees. Congratulations, Representative Comey, on that. In January 2020, she actively participated in the Shared Parenting Symposium at the Legislative Office Building and gave insightful comments and questions in that symposium. Next, we have Senator Derek Slapp, who represents the 98,000 residents of West Hartford, Farmington, Burlington, and the western portion of Bloomfield, Connecticut. Derek makes his home in West Hartford with his wife, Alex, daughters Maggie and Zoe, and son, Charlie. He is Vice President of Advancement at the Village for Families and Children, working to support families and communities in the greater Hartford area. Senator Slapp is a lecturer at Sacred Heart University and has been a lecturer in political science at Yale University and an adjunct professor at Quinnipiac University, Central Connecticut State University, Southern Connecticut State University, and Eastern Connecticut State Universities. In 2017, he won an Archangel Award from ARC for his advocacy on behalf of people with disabilities, and we thank you for that, Senator Slapp. With that said, we will be moving on to our speaker, Attorney Ashish Joshi's work, which focuses on complex family law matters, including severe parental alienation, pathological child enmeshment, child abuse, and international kidnapping. Mr. Joshi has counseled or represented clients in state and federal courts across the United States and internationally, and he has published a number of articles and co-authored books on parental alienation and child abuse. He serves as a senior editor for litigation, the Journal of the American Bar Association section of litigation, on the advisory board for Champion, the journal published by the National Association of Criminal Defense Lawyers, and on the board of directors of the Parental Alienation Study Group. Attorney Joshi will speak about domestic violence as presented in the courtroom when it is raised to either detract, defend against, or justify claims of parental alienation. In other cases, they are the opposite sides of the same coin, and parental alienation, similar to domestic violence, is a part of the family violence dynamic. Attorney Joshi, the floor is now yours. We welcome you to this 5th annual symposium. Thank you very much for your attendance.
Thank you, Colleen. Can you hear me okay?
We can, thank you.
Wonderful. Let me make sure I have this right. Okay, so before we begin on the topic, a little bit about myself. I'm based out of Ann Arbor, Michigan. I'm an attorney licensed in Michigan, New York, District of Columbia, and many other federal jurisdictions. My practice is somewhat unique in the sense that I've had the privilege to litigate cases involving child abuse, parental alienation, domestic violence, international kidnapping in jurisdictions all over the country in the United States and internationally as well. I've been part of the legal team for cases involving child abuse and alienation before the European Court of Human Rights. I have practiced law in India before coming to the United States for my higher legal studies. I continue to work with many countries in South Asia, particularly India. I'm currently involved in a project before the Bombay High Court regarding guardians ad litem, and they are trying to put something in practice. So in a way, my perspective is global, so to speak. And I would like to share with you today my experience regarding cases involving parental alienation, family law, family violence, and child abuse. Couple of books that I have authored. My book on litigating parental alienation was published by the American Bar Association section of family law, which came out in 2021. A year before, I was a contributing author to the book Parental Alienation, Science and Law, which came out in 2020, and I wrote a chapter on international initiatives taken by countries around the world regarding parental alienation. And this was a survey of not just United States, but also countries from the common law background, such as Canada, Australia, New Zealand, the UK, India, and the countries from the civil law background, such as France, Germany, Scandinavian countries, and other Asian countries such as Japan and China, and how they have oriented towards parental alienation and family violence. Some have adopted legislative solutions. Some have continued to deal with this phenomenon by the courts. But regardless of that, parental alienation, domestic violence, and child abuse continues to be heavily litigated in family courts in not just the US, but everywhere in the world. And you find this phenomenon in different ways. You often have allegations of physical, emotional, and sexual violence regarding children or litigant parties. But you also have allegations more and more of coercive control. You also see in some broader, sophisticated jurisdictions shades of another kind of violence, which could be financial control. Sometimes immigration issues are involved, where a spouse is trapped in a very abusive situation or a marriage because he or she cannot afford to go to the court and seek help because of the immigration status. So we see different shades of it. But to focus on parental alienation, the term parental alienation has garnered a lot of controversy, although there is nothing controversial about it. And when we look at the case law from different jurisdictions, including Connecticut, you find that the courts have described the phenomenon using different names. Some courts have talked about parental alienation. Others have referred to the dynamic as pathogenic parenting, brainwashing, programming. Some have used the DSM-5 term, child affected by parental relationship distress diagnosis. Others have just called it parapathological alignment. And some trial judges have flat out said that we don't really care about the label. We are not going to get dragged into the controversy about the label or the name for this phenomenon. At the end of the day, what we are concerned about are bad behaviors that are engaged by one parent against the other parent. And courts have defined the term as well. So if we go to Connecticut, one case that came out of a Connecticut court in 2016 have defined the term as parental alienation is when one parent intentionally disrupts the child's relationship with the other parent. And here the court focused specifically on the behaviors of bad parenting or pathogenic behaviors of the parent, as it should. So what are the requirements before you see a judicial finding of parental alienation? Typically, we find that before there is a judicial or even clinical finding of alienation, one has to see that one parent has manifested alienating behaviors, which are very well described and explained in the clinical and professional literature. And as a result of those behaviors, the child exhibits signs or symptoms that are commonly found in alienated children. So we have a combination of bad, pathogenic, abusive behavior on the part of a parent, and sometimes third parties as well. It's not uncommon to see alienating behaviors on the part of not just the alienating or favored parent, but also grandma, grandpa, aunts, uncles, sometimes unwittingly triangulated school teachers, therapists, and whatnot. Bad behaviors on one hand and their effect on the children and how the child reacts to that programming and brainwashing and alignment after those bad behaviors come into place. We see the findings of fact that have led the courts around the country to intervene, focus on the behaviors of the alienating parent. And these are pretty well described 17 behaviors that the clinical literature tells us about, which are specifically looked into by the courts. You don't need all 17. You could have 4 or 5 or 6 of these bad behaviors, and you could still end up with a pretty significant case of parental alienation. It is important to understand that when we are talking about alienation, we are talking about a spectrum. In other words, you could have a case of mild or moderate or severe alienation. And this would depend not just on the behaviors at issue, but also the resiliency of the child, the emotional connection that the child enjoyed with the targeted parent before these behaviors became an issue, the developmental age of the child, the emotional strength of the child. Not all children are affected in the same way by these bad behaviors. And in fact, it is not uncommon to see, even in a single family dynamic, when there are more than one children involved, you might see a case where, let's say, the older child is significantly alienated from the targeted parent, while the younger child, not so much, or vice versa. So you don't have to see the same effect on each child that the behavior produces. On the other hand, we look at the symptoms that are present in the children. We look at what signs of alienation do these children demonstrate, because an alienated child appears very different in a clinical setting from a child who has been abused. And the research makes this clear. In fact, it has been shown that children who are genuinely abused will fight to maintain some relationship with the abusive parent. Children who have been abused will make excuses favoring the abusive parent. They will try to minimize the abuse. They will try to make up excuses. It's not uncommon for them to say to the protective workers or social workers, well, my father beat me up, but I probably deserved it. Or I know my mom didn't mean to do that. She was just drunk that day and she's trying her best. And they will try to minimize abuse. On the other hand, alienated children show pathological signs of clear and unambiguous rejection of the targeted parent. And a small flaw on the part of that parent is seized upon to make a justification, an excuse for absolute and total rejection in the more severe cases of alienation. So like the 17 behaviors that are manifested by the abusive, alienating parent, there are 8 signs that are well known in the clinical literature that alienated children demonstrate. And again, you don't need 8 signs. You could have 4 or 5 or 3 of these signs and could still end up with a case of moderate to severe parental alienation. So how do the courts look at these cases? What I have found is that when a family court judge takes a look at the case, it is usually after a custody evaluation has taken place or after a forensic evaluation has been undertaken, and a professional, sometimes a psychologist, on occasions a psychiatrist, in some situations a guardian ad litem, but some neutral professional has taken a look at the case, interviewed the parties, interviewed the children, done psychological testing where required, looked at the collateral evidence, interviewed collateral witnesses, and have presented the findings before the trial judge. And in that situation, the court finds alienation to be present when the behaviors or the pattern of behavior makes it clear that one parent is hell-bent upon sabotaging the relationship with the other parent and the child. So let's take a look at, for example, this case of Dean versus Belhino, 2011 case. The court found in this case for the mother to be the alienating parent when she engaged in specific behaviors that were designed or intended to destroy the relationship between the child and the father. But this is not a gender issue. When we look at the cases, we see fathers engaging in alienating behaviors, and we see mothers engaging in alienating behaviors. And there has been research conducted about the difference in how each gender engages in alienation. But this is by no means you can say that it is women who engage in alienation and not men, or vice versa. When we review the cases from not just United States, but from United Kingdom, Australia, Canada, New Zealand, Asian countries, we see that it runs the gamut. Both sexes have engaged in alienating behaviors. Women have been the targeted parent and have lost children in the relationship because of alienation. So have men. grandfathers have been alienated, so have grandmothers. And you will also see this phenomenon even in same-sex marriages and same-sex relationships. Gender has nothing to do with alienation. Again, what is not required for a finding of alienation? It's not required that a parent who is being targeted has to demonstrate all of the 17 behaviors of an alienating parent. It is not necessary that the child has completely rejected the targeted parent. And this is important. Sometimes children do maintain contact with the rejected parent. In many cases, there's been no violation of parenting time. And the judges are perplexed when the parent comes to the court and alleges alienation. The judge's response is, well, I see the kids have been going for parenting time. There have been no violation of your parenting time, no violation of your visitation. So how come mom or dad, you are in my court alleging alienation? And it is important to understand that alienation does not require that the child resist any and all contact with the targeted parent, because there's an interplay here between quantity and quality of the relationship. So there are plenty of case law and plenty of cases where the quality of the relationship has suffered tremendously without there being any gap or gaps in parenting time or visitation. So I have seen cases where children who have been moderate to severely alienated do come for parenting time. These children get dropped off. They have their headphones on. They walk into the rejected parent's house. They go into the bedroom. They shut the door, and they absolutely refuse to engage with the parent. No meal times, no sort of engagement, no shared activities, no conversation. They come with their bags packed, their meals with them, their computers, the battery, the backup power, and they somehow manage to spend those 48 hours or 72 hours with the targeted parent without any interaction whatsoever. And once that box is checked off, they go back to the favorite parent. There are situations where children have even refused to use bathrooms, and they use pee bottles. They do some pathogenic, really crazy behaviors, anything to not get out of that room and not engage with the parent. So it's not necessary that you see a continued violation of parenting time. More interestingly, the courts have also found, particularly Canadian courts, that you don't really need an expert to come to the court and tell the judge that this is a case of alienation. In fact, there have been cases from Ontario where the Ontario Court of Appeals have taken judicial notice of the existence of the phenomenon of parental alienation. And these judges are essentially sending a message that we don't need to waste time, and we don't need to waste people's money on having a debate about whether parental alienation exists or not. That is just silly. When we have case law for the past 3 decades in this country and other countries about the phenomenon of alienation, how it occurs, when it occurs, and what to do about it, is absolutely nonsensical to waste courts' time and people's monies, because time is precious in cases of alienation, to determine whether there is such a thing as parental alienation. So about a year ago, the Ontario Court of Appeals came out with a fantastic decision that said, we as appellate court are taking judicial notice that there exists such a thing called parental alienation. And when it does exist, it causes significant harm to the child and the child's relationship with the parent, and to the child's emotional well-being, generally speaking. There have been cases where the appellate courts have advised trial judges that you don't need an expert. You don't need a psychiatrist to come into your court and advise you or tell you that parental alienation exists in a particular case one parent has behaved badly. I mean, imagine the situation. What would a trial judge do if the trial judge has evidence of physical abuse? If one parent walks into a court and produces medical reports or photographs of the child being physically beaten, black and blue, by the other parent, any trial judge will immediately suspend the other parent's parenting time, order an inquiry, protective services will be called in, there will be a safety plan put into place. An alienation situation is no different, except that the wounds and the injuries are emotional, not physical. It's the same dynamic at play as coercive control. And the trial judges have held that we can do the findings of fact. We don't need an expert to tell us whether some categories of behaviors are emotionally abusive or not. As a fact finder and as a trial judge, we can make those decisions. So this is where it becomes interesting about alienation and some of the false assumptions. One of the assumptions, false assumptions regarding parental alienation is that the detractors of parental alienation phenomenon or theory argue that the theory of alienation assumes that simply because there is rejection by the child of a parent, it must be due to alienation. In other words, if a child is refusing to see a parent or have a relationship with a parent or have any contact with a parent, that refusal in and of itself must be because of parental alienation. And it's absolutely false. The proponents, no legitimate proponent of parental alienation theory has ever said that. If we look at the survey, if we survey the literature on parental alienation, there is no assumption in place. You can only argue or allege parental alienation if you have the alienating behaviors present in a case and evidence of those behaviors. And you have to show how those behaviors have caused the children to reject the other parent. And we'll go to the 5-factor model, which not only requires the alienating behaviors and the signs of alienation in the child, but also requires absence of abuse or significantly deficient parenting or neglect on the part of the rejected parent, and also requires a pre-existing decent, good relationship between the child and the now rejected parent. So the assumption regarding parental alienation is false and deliberately created to create a smokescreen. The other false assumption is that men who successfully defend against the accusations of abuse or domestic violence and thereafter win custody are somehow batterers or abusers with custody. In other words, these are people who simply got away. And that's not true. An allegation of domestic violence in a case involving divorce or child custody is investigated. I know science doesn't look at anecdotal evidence, and you can't really fall back upon your anecdotal experience and generalize that. With that limitation in mind, in my 2 decades of practice around the country, I have represented mothers, fathers, children, grandmothers, grandpa, acted as a guardian, helped out courts, an amicus on some situations. I have yet to see a trial judge in any setting who would simply discount an allegation of domestic violence or physical abuse or sexual abuse as just flimsy. It just doesn't happen. What you do see is once those allegations are pled and investigations take place, and if the charges are found unsubstantiated, there might be repercussions. And in fact, the bias is on the other side in my experience. You frequently see Child Protective Services, CPS, investigate one allegation after another. And if an allegation of abuse is founded if the allegation of abuse is determined to be valid and having merit and is considered to be substantiated in their language. Everyone jumps into action. There is a safety plan put in place. There is psychotherapy tools that are given to the parties. In severe cases, there's suspension of parenting time. Sometimes there's criminal investigation as well. But by the same token, when you have a case of 5 or 6 or 7 allegations of abuse or violence, all of which have been investigated and have been found unsubstantiated, you rarely see clinicians or professionals ask a question as to why. What is behind this pattern of false allegations? Why are these allegations being orchestrated? Who is orchestrating them? Is there malice behind it? Is there unwarranted anxiety behind it? And the negative finding is not given as much importance as a positive finding. But allegations of DV are definitely taken seriously, more and more so by trial judges, protective services, and the professionals. So it is not a question of either or. It is not a question that either it's parental alienation or the rejected parent must be abusive, and that's why he or she deserves to be rejected by the child. This is a false dichotomy. The binary thinking of us versus them, the group that puts themselves out as domestic violence activists or feminists, and the group that's out there claiming victims of parental alienation, it's not us versus them. They're all part of the same umbrella of family violence. The women out there who claim that alienation just doesn't exist or parental alienation is a hoax or junk science are doing tremendous amount of disservice to millions of other mothers and women out there who have been victims of parental alienation. And the same goes for men as well. So this is not a gender binary question or a gender war. The behaviors that are the heart of parental alienation are very much the same behaviors that go into play in cases involving coercive control, psychological abuse, emotional abuse, and domestic violence. They are intertwined and they must be carefully considered when fleshing out a resolution of the case. And it's not uncommon to see a hybrid case. There are cases where the judges have found that we have evidence of both. We have evidence of alienating behaviors on the part of one parent, and we have evidence of grossly deficient parenting or even abusive behavior by the other parent. And in that situation, it's a hybrid case. And the courts have to craft a particular kind of clinical intervention, therapeutic intervention, and custodial intervention to take care of both issues, alienation and abuse. We see the 5-factor model that is often utilized to gauge whether alienation is present in a case or not. And more judges are adopting the 5-factor model. You see that in a clinical setting all the time. And the 5-factor model basically requires investigating the case using the 5 separate factors. And we'll go through that. But it's important to realize that Dr. Amy Baker, who is extremely very well known in the area of parental alienation, child abuse, and has written number of peer-reviewed papers, books, articles, presented in international conferences as well. She has said that it is important to determine whether formal child abuse investigations concluded that the rejected parent had in fact engaged in any form of maltreatment. If you have evidence that the parent who is being rejected, the parent who the child is trying to resist having contact with, if that parent has been found to have engaged in any sort of abusive behavior, you need to treat with caution, because it may not be a case of parental alienation. It may be a case of justified estrangement, and the child may be resisting contact because the parent is indeed abusive. So allegations of domestic violence and child abuse have absolutely to be taken seriously and must be investigated when you're investigating a case of alienation. So what are the 5 factors? The 5-factor model requires that a clinician or a judicial officer who is engaged in fact-finding mission looks at the 5 factors in tandem together. The first is the child is avoiding or rejecting the relationship with one of the parents. The second factor is there is evidence of a prior positive bond between the child and the rejected parent. In other words, if it is the mother who is being rejected by the child, you need to have evidence, or hopefully you see evidence that before the divorce or before the separation, before the rejection became an issue, the mother had a decent, healthy, normal relationship with the child. That this mother who's now being rejected was a part of the child's life, was an involved parent, was participating in parent-teacher school conferences, soccer leagues, birthday parties, vacations, normative parenting, that there is a healthy historical baseline relationship here. Factor 3 is absence of abuse or neglect by the rejected parent. And this happens to be one of the heavily litigated areas in family court cases. And it's important to understand that what we are looking here is abusive behavior, not some questionable episodic parenting decisions. Children do not completely reject a parent for setting down house rules, for making rules as to how much media can a child enjoy at his or her house, for having ground rules as to religion, education, medical decisions, things like that. What we are rather looking to is abusive behavior or questionable parenting or neglectful behavior that rises to the level of physical abuse, alcoholism, a completely neglectful parent who was never around while the child was growing up. Behaviors that would cause any clinician or a judge or a protective services worker to pause and look at it carefully. And if there are findings of abusive behaviors made in the past, those are absolutely important to look at. Factor 4 are the 17 alienating behaviors that we discussed, that there is evidence that the favored parent, the alienating parent, has indeed engaged in those behaviors. That we are not simply assuming that because we have factor 1 and factor 2 and factor 3, hence factor 4 by definition must be present. No such assumptions can be made. You need to look for evidence. Because there have been cases where parents have been falsely accused of alienation. And I have represented such parents where a mom or a dad is being falsely accused of being alienating, when all they're trying to do is to protect the child and protect themselves from the severely abusive other parent, or there's a particular dynamic at play that the parent wants to be concerned about, cautious about. It could be severe alcoholism by the rejected parent. It could be some sort of addiction, such as sex addiction. Sometimes there are issues involved regarding child safety. So you can't just assume that because factor 1, 2, and 3 are present, alienation must be at play. And last but not least, the signs of alienation in the child. because you might have a case involving evidence of alienating behaviors without it becoming a case of parental alienation. And how is that possible? Well, it's possible because while you may have significant evidence of bad behaviors or alienating behaviors, the child doesn't appear to be affected. So you may have a case where one parent has been carrying on a campaign of denigration against the other parent, repeated interference with the parenting time, repeated attempts to orchestrate false child protective services investigations, repeated attempts to send police officers to do well-care checks at the other parent's house. But despite all this negative, toxic behavior, the child doesn't seem to be affected and is not rejecting the other parent. And that may be because of various reasons and because of the intrinsic strong bond between the targeted parent and the child. But that does not mean that the courts or the clinicians have the luxury to sit back and wait until the child is alienated. So sometimes the courts do have their opportunities to nip the problem in the bud and look at it carefully and do some early intervention. So some of the case law that I have included here is Connecticut case law where domestic violence allegations where a party had played a good role in determining the existence of parental alienation. And for example, in this one case, the court found that the court doesn't have to wait until some physical harm has befallen the child. An imminent risk of harm is the standard, and the court should look at that standard when it tries to intervene. But the court also here acknowledged the emotional abuse. Interestingly, in this case, it was the mother who was found to have engaged in that emotional abusive behavior. In yet another case, the court appointed an evaluator in the case, and there were alienating tactics that were played, and the court found a history and pattern of false allegations. And when we consider the domestic violence facts, it is important to realize that from a legal perspective, not all conduct that is alleged to be abusive rises to the level of domestic violence. And different states have different definitions of domestic violence and what sort of conduct rises to that level. In a high conflict, contentious cases, especially in the early stages of the filing for divorce, and when one party is in the process of moving out of the house to an apartment or different place, it is not uncommon to see episodic, suboptimal, or poor parenting choices. But you look at the family dynamic in its entirety, not just what happened in that 1 week when the divorce was filed. What has been the history for the past so many years? The parent who is now being rejected by the child, how was the relationship with the child and the parent up until now? And the courts do pay a good amount of attention to the historic baseline relationship between the child and the now rejected parent. Another interesting case out of Colorado, false allegations of abuse or domestic violence, interestingly, in this case, made by the father, who repeatedly alleged domestic violence against the mother and had testimony and gave their mother was abusive, this, that, whatnot. And the court found to the contrary, that no, these allegations are baseless. And this reminds me of another seminal case out of the court of Tennessee in 2017, Mclean versus Mclean case. It's a beautiful appellate decision where the panel of judges were wrestling with what to do in this case of severe parental alienation. In that case, it was again the father who was the alienating parent, and the father had brainwashed the son into rejecting the mother. And the Court of Appeals in that case went through the evidence. There were painful text messages that the father sent the son. using the Bible to brainwash him, encouraging him to reject the mother, the parent, completely, telling him that no one likes your mother, she is mentally unfit, she is a cuckoo, she is that, she's whatnot. And the son began to parrot those allegations and wanted to absolutely do nothing with the mother. And the Court of Appeals intervened and said, we have been doing this for the past several years. We have tried to do traditional psychotherapy. We have tried to have minors counsel. We have appointed guardian ad litem. We have done family therapy, but nothing is working. And we need to take a look at why. And finally, the appellate panel realized that unless and until the child stops going back into that poisonous, toxic environment that the father has in his home, the mother has no hope of a relationship. And finally, the court intervened, ordered a specialized intervention program together with the suspension of parenting time for the alienating parent. And you see that time and again in severe cases of alienation. And the courts deem it important to remove the child from the toxic environment. Why? Because it is impossible to treat an alcoholic while sitting in a bar. No amount of therapy, traditional psychotherapy, or even family therapy is going to work if the child goes to therapeutic sessions for 2 or 3 hours a week, but continues to spend the majority of the time with the alienating parent who continues to spew that toxic poison. And that's why the courts intervene, change custody, or put no contact orders into place to remedy alienation. Another interesting study done by Dr. Jennifer Harman and her colleagues out of the University of Colorado, it is somehow considered socially acceptable for parental alienation behaviors when they are being engaged in by women, by the mothers, compared to when the fathers engage in them. And Dr. Harman makes a beautiful point that regardless of the gender, these behaviors are never justified. They are always abusive to the children and to the targeted parent, and they do significant long-lasting harms. There are studies associated with alienation and toxic divorces. The adverse childhood experiences studies have made it clear that children who get trapped in these conflicted divorces, children who are subjected to alienating behaviors, engage in self-injurious behaviors such as cutting themselves, drug overdose, sexual promiscuity, violent behaviors in high schools and colleges. There are physiological harms associated with these behaviors, clinical depression, a lack of trust in having a relationship with a significant other or a girlfriend or boyfriend as they grow up. And these harms have been absolutely researched and studied. It's beyond the debate here. So treatment options. And this is another reason why it's important early on to investigate a case for domestic violence, parental alienation, and abusive behavior before rushing off to order treatment or some sort of therapeutic intervention. Because treatment options are radically different when you compare a case involving abuse, domestic violence, coercive control, versus a case involving alienation. In an abuse situation, you are looking at cognitive behavioral therapy that is targeted to rectify and modify abusive behavior. And coupled with traditional psychotherapy, sometimes multimodal family therapy therapeutic options. But in the case of moderate to severe alienation, such therapy, particularly traditional psychotherapy, would be catastrophically counterproductive. And here's why. There's a great book by the title Children Held Hostage that was published by the American Bar Association section of Family Law. And that book currently is in its second edition, is a study of 1,000 families across America. And the authors are Dr. Stanley Clavar and Brian Rivlin. And it's a team of psychologists and sociologists, a social worker as well. And their study of 1,000 families, they identified how children are brainwashed. And this is the exact term they use. They did not shy away from using these terms, brainwashing and programming. And they demonstrated how it works in practice, how this brainwashing took place, how the children were programmed to reject the other parent. And Dr. Claver also came out with another book in 2020 or 2021 called Parent-Child Reunification. The first one was addressing the problem. The second was more addressing the solutions. Where do we go from here? And it talks about different kinds of reunification and therapeutic interventions. And the research makes it clear that traditional psychotherapy in a case involving moderate to severe alienation just doesn't work. It creates immense amount of frustration on the part of the targeted parent, the rejected parent. It creates tremendous amount of anguish for the child to go through those sessions. And it creates a tremendous amount of frustration for the family judges who wonder why it's not working. Why aren't we making progress here? So it's important to determine the problem before we rush off to a solution. And the treatment options are different. An alienation-specific treatment is designed to gently but firmly confront the child's false beliefs and the false narratives that the child has internalized due to alienation. It is not uncommon to find, for example, a child who has been alienated and brainwashed into believing that his mother is an alcoholic, refuse any evidence to the contrary. These children will refuse to believe medical tests. These children will refuse to listen to any other clinician telling them that the mother is safe. They will simply not believe that, and they need experience with the rejected parent. They don't need little speeches from the bench or the judges. They don't need 1 or 2 or 3 hours of therapy. What they need, what is counterintuitive, is but they need significant uninterrupted time with a parent that they have been rejecting, so they could experience that parent and determine for themselves that the message that they have been getting from the alienating parent is false. Alienated children need tools to develop their critical thinking skills. And there are specialized intervention programs that are designed to do that. Some of the common myths and fallacies that often take place or litigated in court. One, as we have discussed, is the gender argument, that parental alienation is a tool that is used against women by men. And that is not the case. Even a cursory review of cases across the family courts in the United States makes it clear that men have engaged in alienation and as have women. And here's a great decision from New York, where a trial judge just dismissed that argument that this is not a gender war over children, that the court rejects any simplistic analysis that says that alienation is simply used by one gender against the other. Another area of controversy is that proving domestic violence is challenging, and judges simply throw out allegations of domestic violence and refuse to investigate them or take a look at them. And that is false. Yes, there are decisions where courts have found allegations of domestic violence to be untrue, having no merit. In fact, sometimes they have flat out called them false allegations. But that does not mean that those allegations were not investigated. There are no such presumptions in family court litigation when you are dealing with allegation of abuse, alienation, or emotional abuse, or sexual abuse, or physical abuse. These allegations are absolutely serious, and they could result into putting a parent on a registry for protective services, which could have significant repercussions on that parent's life, especially if that parent happens to hold a professional license of being an attorney or a healthcare provider, a doctor or a nurse. It could have life-changing consequences. So yes, these allegations are absolutely investigated. There was a paper authored by Joan Meyer and her colleagues, which basically said, and I'm paraphrasing here, that domestic violence allegations are not taken seriously, and the moment a mother or a woman alleges domestic violence, she is met with an argument of parental alienation and she loses custody. And in 2020, there was a wonderful paper published in a peer-reviewed journal by Doctors Jennifer Harman and Dr. Lorandos. The title of this paper was Allegations of Family Violence in Court, How Parental Alienation Affects Judicial Outcomes. And they carefully went through the allegations or assertions made by Joan Meyer and her colleagues. And they found that research to be flawed. They found the research to have unwarranted presumptions. And if anything, the results were contrary to what Joan Meyer and her colleagues alleged. And it's important that this criticism of the Meyer paper was published in one of the highly acclaimed peer-reviewed journals published in America by American Psychological Association, no less. Alienation is a form of family violence. Another great peer-reviewed research paper published by Dr. Jennifer Harman in the journal Psychological Bulletin discussed parental alienating behaviors and how they are within the umbrella of family violence and the power and control wheel, which is used by domestic violence advocates. That when you look at the alienating behaviors closely, you find the same behaviors such as which are part of the coercive control and power and control wheel in alienation situation. And these behaviors are classified into emotional abuse, coercion, threats and intimidation, physical abuse sometimes, using isolation, minimizing the relationship, denial and blaming, gaslighting, using privilege, especially in a cross-cultural issue, using economic abuse, and using children as weapons. Another case that you could look at, outcomes of family violence. Alienation similar to domestic violence and intimate partner violation, intimate partner violence leaves scars. Children who have gone through alienation, children who have been subjected to these alienating behaviors have demonstrable negative outcomes. It has been shown that these children have shorter lifespans. They develop internalizing behavior such as depression, anxiety, social withdrawal. They also manifest externalizing behavior such as aggression and acting out, poor academic performance, neurological damage, cardiac arrest, lots of other problems. The Spinozzola studies have made this clear as to how the children are affected by them, including the post-traumatic stress. It is not a binary equation. It is not a zero-sum game. And it is extremely disheartening to me when I come across an argument made by one group against the other, call it a women's group versus men's, or men's against women, mothers versus fathers, or fathers versus mothers. This all behaviors, as the courts see it, are part of the family violence umbrella. Alienation involves psychological abuse. Alienating behaviors are emotional abuse. And these behaviors leave bullet wound injuries that you can't see, but they are emotional, they're long lasting, they leave scars on the children, and they cause tremendous harm. And yes, the courts around the country have overwhelmingly acknowledged parental alienation as emotionally abusive behaviors, and they have intervened when they have found these behaviors. So it's time that we move on and not have debates about whether alienation exists or not. Because anyone who claims that parental alienation is junk science or doesn't exist, or courts don't acknowledge that, is simply being willfully blind to the professional literature out there, clinical literature, peer-reviewed literature, and most importantly, judicial case law that continues to come out almost on a daily basis from family courts across America. I put together some of the references and resources for that you could look at. If you need more information, here's my email address and my website. And now I'd be happy to answer any questions that you may have.
Thank you, Attorney Joshi. That was an incredible presentation, so thorough and thought out and just so informative. And I thank you for doing such a great job and taking the time to come and present to us.
My pleasure.
I have a question, and not really a question, just more of a comment before we go on to questions from our legislators and from our audience. But one of the things that really stuck out for me, having done this work and dealing with families of divorce and being divorced myself, was the us versus them thinking. And the parental alienation versus domestic violence, and kind of really being one and the same. But then as I kept thinking and listening to more of your presentation, really went on to kind of your conclusion, which is us versus them, which is really other organizations making it kind of, and other people's mindsets. And I think it's kind of set up this way where we oppose each other, making it a gender issue. And it's not, it's male, female, husbands, wives, mothers, fathers, and the people who get hurt the most are our children. And that is something that I think we have to keep at our forefront when we're doing this work and trying to create change, is really that common theme of coming together to create the change for children, not only in Connecticut, but as you said at the outset, just globally, because it's a global issue as well. And with that, I will thank you, and I will open it up to our legislators. First, we have Representative Comey, we have Derek Slap, and I believe we're honored to have, if I'm not mistaken, Representative Kate Farrar here as well. So if there's anybody who'd like to start from the legislators, we'd like to take your questions or comments first, so that we know you're busy with your schedules as well.
Thank you, Colleen. Thank you so much for asking me to join this forum today, and thank you for your advocacy on this important issue, and John, for really keeping me in the loop and other legislators in the loop on the work that you're doing. I think it's really important to have the checks and balances that we need with someone like the Shared Parenting Council, and also be a resource for families that are experiencing high conflict divorces and custody battles. So I was thinking, thank you for your really great and thoughtful presentation, Attorney Joshi. You really laid it out really so beautifully. And I was wondering, I recently had someone who came to me and was experiencing some of these things, I believe, I don't know, but she was describing some of the situations she was in. And her child was very young, really young, like 2 when things started to happen. Mm-hmm. And I'm just wondering, she was having trouble in the court system, in the family court system, because the child wasn't really verbal, or wasn't able to express what sort of abuse and things that she had described. And so I'm just wondering, how do you handle when really young kids are involved in these issues?
That's a great question. And just as an aside, a couple of months ago, there was a great conference put together by clinicians and judges in Europe, which was in European Parliament in Brussels, hosted under the auspices of Parental Alienation Study Group, PASG 2021 conference. And the focus of this conference was early intervention. What can the judges and clinicians and professionals do before the children are alienated? And often it is psychotherapy and the tools that the parents need to understand how some of those behaviors that they engage in, when they are angry at each other, when they want to hurt each other, when they are going through a contentious divorce, but they end up inadvertently hurting their children. So there are cases where a parent is engaging in behaviors that can be classified as alienating behaviors, but children are simply too young to be affected by that. But that does not mean that we don't try to stop it, because if those behaviors are left unaddressed, the children will at one point in time start getting affected by those behaviors. And in those cases, the best thing to do would be to send those parents to psychoeducational classes. It could be court-ordered counseling. It could be having those parents go through some of the books and videos that are available. For example, one of the best documentaries I have seen on this is a video called Welcome Home, Pluto. Welcome Home, Pluto is a docu-movie that was put together by Dr. Richard Warshak, one of the best known experts in this area out of Texas, who is also the author of the book Divorce Poison. And Welcome Home, Pluto engages in role playing. It does not cast blame, but it engages in role playing situations so that parents mainly, but also older adolescents, teenagers who are 14 or 15 could also watch those series, and they realize what has been happening. And they are able to catch those behaviors and not repeat them. And judges too, the judges show enormous amount of patience. They don't rush right away to the punitive track. They use the carrot and the stick approach as well. And the carrot approach is psychoeducation and giving these parents a tool that they need before they feel the need to take the punitive approach and start punishing them for the bad behavior. But if you have a child who is young, if you have a child who is not yet reacting to the negative behaviors, then that's a wonderful opportunity that you can and should take to stop those behaviors at the outset.
Thank you very much. I just have one more question. In right now, right? we're in this crazy time in our lives here in the country. We've seen an increase in domestic violence, and the stressors in people's homes, and increase in divorce. And in our world is I don't even know if this is a question or more just a comment. I think our world is so divisive now, and the dynamics of our interpersonal relationships are dysfunctional. I feel like sometimes more so than they have been. And I think that if you throw in some of these emotional stressors of divorce and domestic violence, as we talked about, and conflict, it really is a recipe for disaster for so many of us. And so I guess the question is, are you seeing this sort of ramp up more based off, where we've been in the past 2 years?
Well, no doubt, alienation has been in the forefront lately, and it's due to several reasons. First, it is because of the awareness that the topic has generated. We see more and more publications, particularly in popular media, such as TV shows, magazines such as Psychology Today, The Atlantic, New York Times, Washington Post, and others have more and more covered this topic. But you also see at the same time a raft of allegations claiming alienation when it's not really the case. I mean, I can't tell you how many times I get contacted by a parent screaming parental alienation. And when you look at the case and you go through the factors and you do an analysis, you find out it's not the case. It's not true. And the same holds true for judges as well. So alienation is a pretty significant, unique, pathological dynamic that, if true and if it exists, does need to be reversed, does need intervention. But at the same time, not every case of high conflict divorce or every case where a child is resisting contact is a case of parental alienation.
Thank you so much. I will let somebody else go, and if I have something else, I'll let you know, Colleen. Thank you.
Thank you very much, Representative Comey. Maureen, you have your hand raised. If you can unmute, Maureen, please.
Yep. Hi, my name is Maureen Martowska. My son's case was probably one of the most high-profile cases for parental alienation in the state of Connecticut. The case had entered the system in 2005, and until November of last year, when the child is 16, has more or less culminated. My family has probably been exposed to every inch of how the courts, therapists, any third party appointed to families can undergo the court system. And I am also a retired attorney. I live up in Massachusetts, but I'm very familiar with Connecticut, and most people here perhaps recognize my name. I have been involved with legislation to try to address parental alienation. I most recently testified to Jennifer's Law and my concern about the weaponization of language that is so broadly drafted that both sides, parental alienation and domestic violence, will greatly utilize that law to bog down the courts. Most importantly, what Attorney Joshi has presented to you and has taken me years to understand by working with psychologists, psychiatrists, lawyers, and judges. You have just been given the benefit of a great deal of education. And it took me a long time to get there. But I will tell you this, looking back in hindsight, if I had to give you the highest suggestion of how this system can be corrected, number one is early intervention. Early intervention in a system that can recognize parental alienation as abuse, because once a void happens and you're waiting for the next court date, which may take 2 months, or in today's system may actually take 6 months, it is a horrendous, devastating impact to a case involving parental alienation, because it sets the vacuum for the seeds of alienation to fester, especially during this time of COVID, when parents have such difficulty getting to the courts. It's immensely important. Number two, in the case of, in the state of Connecticut, most cases who come through the family court doors are not involved what is known as single calendaring. Most family court cases, a lot of times, come back to court and you're not assigned the same judge who can have the benefit of overseeing how this case and the dynamics are playing out. As the case progresses, and there is a long history of therapists, child therapists, reunification therapists, guardian ad litems, all the expenses and all the exercises and hurdles that families have to go through to try to get to a resolution and try to get the court to see the problem is not given, it's not seen by many courts because of this system where single calendaring isn't in place. It should be in place for people having high conflict cases. But again, I want to stress the utmost importance of early intervention, certified training for therapists in cases that involve parental alienation. And one other thing that I think Attorney Joshi probably ran out of time is in educating you and telling you that with these cases, the majority of cases involving parental alienation involves one or both parents having a Class B trait as far as narcissism, antisocial behavior, histrionics, and there's also one called borderline personalities. And that's extremely important to note because cases of parental alienation are counterintuitive. That is the one phrase that I hear when I hear Dr. Lorandos, Dr. Miller, Dr. Amy Baker, the global experts in these fields point that out. That is counterintuitive. So judges, therapists, and guardian ad litems, everybody needs to actually have, I feel, specialty training with regard to parental alienation to really understand it. But I want to thank Attorney Joshi because I think, again, that everybody has been given a great deal of information. And I wish that they would recognize, I think one of the big steps Connecticut could make is to think about legislation, incorporating legislation as he, you know, at the end of his presentation, when he presented that wheel of all the overlapping things that are common to both domestic violence and parental alienation, whether it's isolation, coercive behavior, economic issues. A lot of these are so common to parental alienation that parental alienation, just like domestic violence, should be considered child abuse. It should be laid out in plain language by the legislators to give the guidance to the courts and the mandate to the court to do something about it, because certainly in Connecticut, it is a two-tiered system. If you come into court and you are claiming a legitimate case of parental alienation, you need supports and you need help and you need it now. Instead, if it were a DCF, a case involving real physical abuse, where DCF comes in with the supports, the investigation, you're on a path of correcting the behavior. In family courts, just the mere allegation isn't enough if there's no history of abuse. In a lot of cases, the parents are left dangling with this. It's years of litigation and years of a lot of financial devastation.
So Maureen, I'm sorry to interrupt, Maureen, but yeah. Attorney Joshi has to leave at 3 o'clock.
Sure.
I was hoping you had a question for him, so that we could make use of his time a little better. And,
so my question would be, Attorney Joshi, why is it, do you feel that many judges are reluctant to reverse custody where they can acknowledge that there's parental alienation. They've had the experts come in and testify it, but they are reluctant to do anything with modifying the visitation or reversing custody where it's needed in the severe parental alienation cases.
That's a great question. And I don't know. That's the honest answer. I don't know. I wrestle with it at my end. I have certainly worked with many judges and put together conferences and papers and have had discussions about this issue as well. But I must say that those judges are in the minority. The majority of the judges do take action. They might not change custody because every jurisdiction needs a threshold level for a change of custody. And sometimes the facts do not rise to the level. They also take a look at the severity of alienation, how severe it is. Mild or moderate alienation may not require a reversal of custody. And at times, the child's age is also a determinative factor. If the child is 16 or 17 and closer to age of emancipation, a custodial change may not work. What might work is a temporary suspension of parenting time of the alienating parent and the child, and an order of specialized intervention program, and giving the targeted parent the decision-making power he or she needs to get the kid into that program. But when you look at the cases, if there is evidence, clear and convincing evidence of alienating behaviors that have shown significant harm to the child in the relationship with the child and the other parent, courts have intervened. Some judges don't, and that may be because of the inherent bias sometimes. Some fail to understand the phenomenon of alienation. Some judges appear to believe erroneously that the children will come back on their own when the litigation dies down. Some subscribe to some beliefs such as you can't really force a child into love, and fail to understand that we are not talking about love, but we are talking about a pathological pattern of behaviors. So there are a lot of ifs here, but overwhelming number of courts have tried to intervene with some sort of measures, leading from custody change, sometimes even incarceration. Judges have not been shy of throwing an alienating parent in jail for repeated violations of court orders and repeated contempt issues.
Thank you. Thank you, Attorney Joshi. Thank you, Maureen, for your excellent insight. Ms. Cocciola, if you can unmute, Ms. Cocciola, please.
Yes, thank you. Thank you so much. I'm happy to be here. I actually just wanted to kind of piggyback a little bit on what Maureen was saying. I'm actually researching right now coercive control as part of my doctoral program at NYU, and the coercive control of children. And what we really see very clearly is that this whole idea of children turning against one parent oftentimes is based in coercive control by a pathological abuser. And so I think it's really important that we begin discussing educating judges and lawyers on what pathology can actually look like in the courtroom. I wonder if you agree, Attorney Joshi, but this idea that offenders often come in and they seem or appear to be people who are very concerned about the well-being of their children, when actually their main focus is to harm the adult victim, and they do that by using children as pawns. And so I really feel that this conversation is helpful, but I think the focus on parental alienation is actually dismissing the problematic behaviors that we continue to see by people who are significantly pathologized and will do almost anything or will do anything to harm the adult victim. And if we're not willing to acknowledge that as judges and lawyers and social workers, by the way, certainly therapists often can gaslight a client into saying, oh, it's anxiety or depression you're suffering from, versus saying, wow, there's something very disordered in your personal relationship with your partner. And so I just I think it behooves everyone here to begin really thinking in that way. And so when someone says, I have been alienated against, I think some of the first questions need to be, why would that person say that? Why would they say that? Because the problem is if they are saying that because they are intending to control and have power over an adult victim and thereby the child or the children victims, that's what we need to be recognizing. That's it. I'm done. Thank you.
Thank you. Great question. Attorney Joshi?
Well, I agree that alienation cases often involve severe personality disorders. And you see people who have undiagnosed personality disorders, severe traits of narcissism, sometimes even narcissistic personality disorder, bipolar, and other issues come to the fore and engage in those pathological behavior. The problem is that judges often resort to appointing guardians ad litem or minors counsel who happen to be lawyers who are ill-equipped to investigate these cases. Massachusetts, for example, has two different categories of guardians ad litem, Category E and Category F, where a court could decide to appoint a psychologist to investigate a matter involving abuse, alienation, or the court could appoint an attorney. But most jurisdictions end up appointing other lawyers who simply happen to be the next name on the roster that the court randomly picks, or the old boys network, And these lawyers have no training, experience, or skill in dealing with alienation, abuse, and enmeshment cases. The first thing they do is to come on the board and start spewing opinions. For example, one of the most egregious mistakes that guardians ad litem make in a case involving alienation is to say, tell the rejected parent, calm down, let's have a cooling off period. Don't force the child to come on visitation. Let's just cool down everyone. And what happens in the quote unquote cooling off period is alienation is further entrenched. The child does not have any contact with the rejected parent. And months go by, people get busy, and the situation goes from bad to worse. It is unconscionable for a court to appoint a professional of this nature in a case involving alienation without any training. It just happens again and again and again. The other problem is, frankly, what I call unscrupulous lawyers. Lawyers believe that they have to go to the mat for the client, that they are the advocate for the client's position, and they don't have a dog in the fight, so to speak. I disagree in cases like this. And I frequently see lawyers claiming parental alienation is child abuse in a case when they are representing the alienated parent. And the same lawyer in another case calls parental alienation junk science when he or she is representing the parent who is alleged to be the alienating parent. And I've called this out repeatedly. And judges don't take action. And the lawyer's position is that we don't know. We are not scientists. There are equal argument on both sides. So yeah, in that case, I was in favor of this parent. In this case, I'm in favor of this parent. But what happens is we have a loss of precious time. The child ages out of the system. A child who is 12 years old and could be saved by proper and right intervention is now 15 years old because the court wasted 3 years on debating the science behind alienation and thousands of dollars spent on that without intervention. And that's a problem.
Thank you, Attorney Joshi. And I actually couldn't agree more. I see a lot of people nodding their heads on that one. So let me just go to John Saxon. Mr. Saxon, your hand is raised. If you could unmute him, please. Thank you.
Okay. Hi, yeah, my name is John Sakon, and
I'm sorry.
Sakon. That's fine. It's a very common mistake. There's a very serious issue in Connecticut about parental alienation that has pretty much gone undiscovered, and it is massive in scale. And I have been the victim of that particular alienation, but let me outline it so far. In Connecticut, there are 27,000 protective orders issued each and every year for domestic violence. 80 to 90% of those protective orders are issued against men. This, and I'm going to lay out the statistics here.
Mr. Second, I just want to be mindful of Attorney Joshi's time, that he has to leave at 3 o'clock, and we do have other people who have questions. So I just want to be mindful of that for you.
So what I'm trying to lay out is according to, and this is a very buried study by a woke society, according to the Centers for Disease Control and the Department of Justice, in a national survey, not a national study, a national survey in the United States, men are far more likely victims of domestic violence than women. That is something that you do not hear. But that was a national survey commissioned by the Department of Justice under a congressional investigation. Okay. What happens is we have weaponized, and I believe weaponized, domestic violence in custody fights. In my particular case, just so that you understand this, in my particular case, I was the victim of domestic violence. My left eye is a broken eye socket. I had heart surgery when I was kicked in the chest. When I reported this, no action. When I reported this to a mandatory reporter, there was no mandatory report made. When I said to my wife, I want a divorce because you're an alcoholic, which she admitted to, and she admitted to drinking while she attacked me. The next thing I know, I says, I want a divorce. Within 12 hours, picked up the telephone, called the police, and I had a protective order against me. I was arrested, gentlemen, for ripping up a piece of paper. In that incident, if you listen to the 911 tape, the woman attacks the man.
Do you have a question to take on?
Okay, I'm going to lay this out.
Can you get to your question though? I'm going
to get to my question. I'm going to lay it out. The weaponization of that protective order goes to, I didn't see my child for the better part of a year. I was then arrested for walking past my wife in a court of law. I was then arrested for having my minister contact my wife to arrange visitation as suggested by a judge. I was then arrested for sending 2 settlement proposals to opposing counsel's divorce attorney. I was then arrested and sent to prison for sending an email to Little League. And since I forwarded the email and replied to all, I did not realize that my wife's name was on that email. So I went to prison for having sent an email to Little League asking that the guardian ad litem's email be added to the Team Little League list. And then I went to prison, in a supermax prison, for 4 months because I gave my son a $100 bill on his birthday and wrote on it, to Odin, this is for your clothes and your haircut. I was exonerated of all the charges. There were 14 felonies and 1 misdemeanor. I was 16 felonies I was accused of. I was facing 157 years in prison. I was exonerated of all the charges. My question is, has the domestic violence system, which is very sensitive to women, now the problem that you have is you go to an interval house or the like.
Mr. Sakan, can you get to you were just going to your question. Can you continue on with that, please? Because we are short on time. We are short on time.
How do you prevent, and by the way, the courts, presently I have 60 motions for contempt for lost visitation, 60. How do you prevent the use of domestic violence as a weapon in parental alienation?
Thank you for your question, Mr. Sakan.
How do you prevent the use of domestic violence as a weapon? Well, in the same way that you would prevent the use of parental alienation as a weapon. I mean, both sides and both phenomenons of domestic violence and parental alienation are often thrown around, There are false allegations of alienation, much as there are false allegations of domestic violence. The problem arises when there is not time spent in the initial stages to do a thorough investigation. And people just agree to some sort of a status quo or agree to just move the charges along, cooling off period or whatnot. But when the investigation is done and the findings are unsubstantiated or substantiated, you need to then go forward with those findings. The mistake that many attorneys and clients sometimes make is to agree on some sort of settlements while investigations are going on, or not have those issues litigated early on. So the ghosts of violence or ghosts of alienation continues to just move around the case for years to come. But I don't see a foolproof way of false allegations being completely taken out of the litigation system. That's a negative side of our adversarial judicial system.
Thank you, Attorney Joshi. I see, John, you're in queue for the next question. John Clapp.
Okay, one quick observation, and that is any domestic violence, male against female, which is more common, or female against male, is definitely a really sad and horrible thing that comes out of these domestic relations, and I'm totally in favor of all the laws and efforts we make to try to restrict that and punish it. But my question for Joshi, Attorney Joshi, is about the things that Shared Parenting Council are doing to encourage mediation rather than litigation at the very beginning. So my point is, at the beginning of the case, when you first start this process, starting people on a triage and pathways and mediation approach. And I think that this might nip some of this high conflict stuff and some of the false allegations on both sides of DV and PA and all of this stuff, and might even stop PA in some cases. Because, I think PA comes out of this whole emotional turmoil sometimes, not always. I mean, sometimes it's an extreme personality disorder, but I think it can often come out of this whole thing of emotional turmoil and litigating, hiring, lawyering up and battling it out in court. And then, you sort of like, it's like a war in the Middle East. It just keeps escalating. That's my opinion. I just wonder what Attorney Joshi's idea is about that.
Now, mediation is helpful in cases of mild alienation, and especially if it's done early. If the parties are amenable to get the psychoeducational tools, then it's absolutely worthwhile. Mediation in cases involving severe alienation or moderate to severe alienation rarely succeeds because it is extremely unusual for the alienating parent to admit that he or she is engaging in parental alienation. They will do whatever is necessary to make up facts, to pretend that they need to protect the child from the other parent, regardless of the evidence to the contrary. It borders on like delusionary behavior. And you can't expect that kind of a person to engage in reasonable and honest mediation. In those situations, it's just a waste of time. The sooner you get to litigation and a trial, the better off you are.
Thank you, John. Thank you, Attorney Joshi. Ms. Mclean, if we can unmute Ms. Mclean, thank you.
There we go. Hi, I just wanted to come on here for the fact that I've been involved in parental alienation syndrome and parental alienation for 30 years now. And I agree with Mr. Joshi because we do need these attorneys and GALs not to be involved in these parental alienation cases and to understand what parental alienation really is. And as far as domestic violence goes, most of these cases are domestic violence cases that move into the abuse of the children, and it is parental alienation that is going on. And it's almost a reverse role, what I've seen for these last 30 years, that when I'm going to use a mother. When a mother comes forward, I've dealt with thousands of cases, and she comes forward with abuse on her child. The courts are ruling, or the father's bringing in, or the other attorneys bringing in parental alienation. Parental alienation syndrome is about abuse, and parental alienation, when there's child abuse going on, it's not about alienation, it's about abuse. And I just think that people that are getting involved in this do not understand child abuse, child sexual abuse, domestic violence, and they don't understand alienation, what's really going on. And I think the term needs to go away, but as long as it's here, we need help on making sure that you understand that a lot of times you go into court and there's domestic violence going on, and the judge is throwing out the domestic violence and they're not allowing it in, and the abuse is going on, and they all of a sudden it's alienation because somebody's trying to protect their child or they're trying to protect themselves. It's not about alienation. That's the problem. That's what I see. And I know I'll let you guys go on with that, but that's what I'm seeing.
Thank you, Ms. Mclean, for your comment. Thank you.
And I do have one more thing to say.
Okay, I'm sorry, go ahead.
One more thing. I am an expert in this area, and the reason I am because Dr. Richard Gardner is who brought this in over in the 80s, determining that parental alienation syndrome, even in his own self-published books he put out there, that we all have some pedophilia within us, makes little girls and little boys their sexual partners. And during that time that he was pushing his books and his thoughts, it has gone to parental alienation, and there are parents that alienate. But my book, I wrote a book called Prosecuted But Not Silenced, Courtroom Reform for Sexually Abused Children. I've worked on this every day for 30 years. I speak all across the nation at law schools, at conferences, where there are the professionals coming in to listen to this. And my book is Courtroom Reform for Sexually Abused Children. And I think it's critical for all judges, all lawyers, all social workers, all people involved in the system to read this book, because it tells the emotional story, but behind it is the research and the legal. And let's wake up to what really parental alienation is, because that book will show you.
Thank you very much, Ms. McLean.
Thank you for your time.
And for sharing. Attorney Joe, should we just have a few minutes left? And did you want to wrap up? Obviously, you've heard from a lot of people, a lot of this passion, there's a lot of passion here. It's our families, our children. There's abuse, and there's domestic violence, and there's parental alienation and not seeing our kids. And you know, that weighs heavy on a lot of people's hearts, and it touches grandparents, aunts, uncles. You know, it's a whole thread of a family that gets affected by things. So it weaves through society. And having been a former teacher, I've seen it in classrooms and how this affects children's education. And I don't even understand why at an educational level, we're not more hyped up about, we're more worried about state testing scores for our children while our families at home are a mess. I don't see how the kids can test well, but that's a whole separate issue. But I just want to, hear from you. Do you have any words of guidance, advice for how to stay the course, how to change the course, and how to do things differently? We'd love to hear a little maybe positivity towards the end of this.
Sure. Thank you, Colleen.
Thank you.
I think we need to remember that at the end of the day, it's about the children. We need to put the children first, and we need to take a hard look at the evidence. It is not uncommon in the family courts to get dragged down into esoteric theories about what Gardner said 2 decades ago. There's been tremendous amount of research since Dr. Gardner, not just in America, from around the world. It is unequivocal that alienation exists. I mean, it is beyond debate that parents who engage in well-known alienating behaviors end up causing significant harm to the children and to the targeted parent. In cases where those behaviors of, let's say, a parent is trying to protect the child from the other abusive parent, that evidence has to be demonstrated to the court. There are courts which have wrestled with this situation. In fact, I'm giving a continuing legal education course next week for judges and lawyers. And the title of my presentation is When the Glove Doesn't Fit, False Allegations of Parental Alienation. There are parents who try to hide their abusive behavior and accuse the protective parent of being an alienator. No doubt about it. I've been in those situations where my client is trying to protect the child from severely abusive parent. But you have to demonstrate the situation and the need for protection. What often ends up happening in those situations is lawyers get dragged down into debating whether Gardner was right, whether parental alienation is a real thing or not, whether it exists in DSM-5 or not, and that's a waste of time and resources. And that's why when you put the children first and you look at the evidence in the case and you look at what's required, if it is protective parenting, why? If it's alienating behaviors, why are they in place? What's going on? We get to the bottom of the matter in as best a way as possible. But I think if there's one thing that I emphasize on is education and training for professionals. Professionals who handle jobs or roles of guardians ad litem or minors counsel, or even taking on high conflict divorce cases. Lawyers, social workers, clinicians, psychologists, they need to be trained in domestic violence, coercive control, parental alienation, and pathological child enmeshment. And without that training, you can't be expected to do a competent job. And we are talking about people's lives here, children's lives. And the book written by Amy Baker called Ties That Bind, Adult Children of Alienation is heartbreaking when these children grow up and realize that they rejected a parent through their entire lives almost. And that parent did not deserve that rejection. That self-internalization of that guilt is devastating to these children. But it's 3 p.m. and I need to rush.
Thank you, Attorney Joshi, for your time and excellent presentation.
Thank you.
Thank you very much.
Excellent.
And this is the conclusion of the symposium for today. We appreciate everyone who has attended. We look forward to seeing you next year. Anyone who'd like to reach out to us, where you can find us at our Shared Parenting Council of Connecticut website. Thank John Clapp for his continued efforts, Dr. Cannon for his help in behind the scenes technology. And we thank everybody in attendance and look forward to working or with everyone or hearing anybody's continued feedback, which is helpful to us. Thank you, everybody, and see you next year.